Hello all, welcome to the new Simply Put series by Kalam Academy. This is Priyanka Mahapatra, faculty at Kalam. So today we'll be having a discussion on the newspaper dated 12th December 2023. So yesterday was a big day. We got the verdict on Article 370 finally after a 16-day long hearing. So all the articles in the newspaper as are pertaining to that particular article as seen in the explain section of the Indian Express newspaper. So whatever articles we have got with relation to the Article 370, we are going to discuss that in detail. Other than that, the text and the context section of the Hindu newspaper had an article about the Bihar reservation pool. That also we are going to discuss. These articles are very important from our exam point of view. So these four articles we are going to discuss today about the 370 verdict, about Karan Singh's proclamation of 1949, which was been cited by the Supreme Court to uphold the abrogation of Article 370. Then we will talk about the Truth and the Reconciliation Commission, right? And then we would talk about the Bihar reservation poll that appeared in the Hindu newspaper. Right. So let's now come to the first article of the day, that is key aspects of Article 370 verdict. So yes, Supreme Court in an unanimous ruling in the ratio 5:0, it has upheld the centre's abrogation of Article 370 of the Constitution of India. And Prime Minister Modi writes in elation that the Supreme Court verdict on Article 370 has strengthened the spirit of Ek Bharat Shresth Bharat. Right? So, Chief Justice of India D.Y. Chandrachud has therefore upheld the constitutional validity of the two presidential orders that was passed in 2019, that is number 272 and 273. So, what are these orders about? It said that the entire Constitution of India is now made applicable to J&K, and second, that all the provisions of the Article 370 stands inoperative. Right? So let's now see the main areas on which the whole debates were based on. The whole 16-day long period proceedings were based on. What were the challenges? How did the court and the judges respond to? Right? So the first one being was the unique and the special status given to Jammu Kashmir. If at all we had given some special status, so does it mean that we allowed sovereignty of Jammu Kashmir? Again, if Article 370 a temporary or a permanent feature, then we also questioned and challenged the legality of the abrogation of the Article 370. Then we questioned the President's rule also. The center took a very indirect approach towards abrogation of Article 370. So that was also questioned. So let's see one by one. So the first point, the first area which was much debated was the special status given to Jammu and Kashmir. So the petitioner said that if any special status is given to Jammu Kashmir, that means it is having an element of sovereignty to it. It was having an element of sovereignty since 1947 when the special status was given to it. Right? But the judges said no, it is not like that. Article 1 of the Constitution of India states that India is a union of states. And Jammu Kashmir is very much a part of Article 1 of the Constitution of India. It has been listed as the Part 3 state under the Article 1 in the first schedule of the Constitution of India. Even the Section 3 of the Constitution of Jammu Kashmir has declared that Jammu Kashmir is an integral part of India. And Section 147 of the J&K Constitution, it has prohibited any amendment done to the Section 3. That means Jammu Kashmir being the integral part of India, it cannot be amended or changed. Right? And when the petitioner said that already it is having, the J&K is having an element of sovereignty, and before actually deleting the provisions of Article 370, we needed an agreement of merger in the first place. The J&K has to be merged into India before actually submitting or surrendering its sovereignty. Then the Supreme Court said no, the merger has already happened in 1949 when Yuvraj Karan Singh issued the proclamation adopting the Constitution of India on November 25, 1949. So it had effectively had effect of merger like any other princely state that time. So Yuvraj Karan Singh is actually the son of Hari Singh, who signed the instrument of accession with Jawaharlal Nehru with respect to the union of J&K with India. Right? So that time the merger had already happened with the proclamation of Yuvraj Karan Singh. So there was no need of any merger. And secondly, on the sovereignty, J&K was not having any sovereign element to it because it was an integral part of India from the very beginning. Right. Then we come to the next debated area, that whether Article 370 is a permanent feature or a temporary feature. So the petitioner said that Article 370 is a permanent feature because it formed the original part of the Constitution. Thereby, it is the part of the basic structure of the Constitution and we cannot abrogate it. It cannot be tinkered with. That was the first challenge and the argument of the petitioners. Second was that Article 373 allowed any abrogation to the Article 370 only with the recommendation of the Constituent Assembly of the state, which is actually not existing today. So how can we abrogate the Article 370 if the Constituent Assembly of the state is not existing today? Because under Article 373 we had to have the recommendation of that Constituent Assembly of that state in order to make any changes to Article 370. So these were the base for the challenges of the petitioners. So what was the judge's response? The judges said no, Article 370 was always a temporary feature. It was just an interim arrangement done before the Constituent Assembly of the state was formed. Right? So in this interim period till the Constituent Assembly of the state was forming, we needed a legal bridge between the J&K and India. Therefore, the Article 370 was given as a power, as a special status to J&K. Then after the J&K Constitution, that is framed by the Constituent Assembly of J&K, right, after the Constitution was enacted and it was adopted, it was not necessary to have that Article 370 anymore. So it was always an interim arrangement, it was always a temporary feature. And because there were some special circumstances in that state during the time, that is the war conditions, that is why this arrangement was given very temporarily. It was not meant to be permanent. Right? So this was the judge's point of view, based on which it has upheld that Article 370 was a temporary feature. Then we come to the legality of the abrogation of Article 370. So the petitioners challenged the legality of the abrogation of Article 370, the procedure by which the Article 370 was abrogated. Right? So we discussed yesterday that how Parliament took an indirect approach to abrogate Article 370 because it was not having any direct powers for abrogating Article 370. So what it did, it passed two presidential orders in 2019. So the first presidential order 272, it changed the meaning of the Constituent Assembly of J&K altogether. It changed from Constituent Assembly of J&K to just the Legislative Assembly of J&K, which was existing till 2019. Then through another Presidential Order 273, it assumed the powers of the J&K legislature by imposing the President's rule there. So after assuming the powers of the legislature, it recommended for the abrogation of Article 370. Right? So this approach, this indirect approach, this witty approach was challenged by the petitioners. So what did the judges respond? So they said that this circular approach was not at all necessary. The president was already having the power to unilaterally abrogate 370. So after the dissolution of the Constituent Assembly of J&K, the power of Article 373, that is, so this article, what it said, it gave powers to the Constituent Assembly to recommend for the dissolution or for the abrogation of the Article 370. But when the Constituent Assembly dissolution happened, then the power under 373 of the Constituent Assembly to recommend for the abrogation got seized. Together with the dissolution, this power also got seized. But again, you have to understand that only this transition power of Constituent Assembly got seized. But the power of the President to abrogate, to unilaterally abrogate Article 370, which was guaranteed under 373, did not get affected. It was there always. So therefore, the judges said that the president always had the power to unilaterally abrogate Article 370, which was guaranteed under 373 article. Right? Then the question arises that if the action was taken under the president's rule, valid or not. Right? So here the extent of powers that can be appropriated under Article 356, that came under question. So it was questioned that whether Article 370 could have been abrogated when a state is under the president's rule. Was president having enough powers to give consent for the revocation of the J&K special status? Right? So the judges responded by quietly relying on the Bommai ruling of 1994. Right? So it relied heavily on the landmark judgment of 1994 in the SR Bommai versus Union of India case. So the constitutional validity is based on two premises over here, what the judges said. So the two premises which the judge talked about is very, very necessary to check the validity, to test the validity of the executive orders. And in this case, it is to check the validity of the action of president to give consent for the abrogation of the Article 370. So the two standards are given by Justice P.V. Sawant and one by Justice Reddy. So according to P.V. Sawant, we have to assess that if the exercise of power was driven by any improper motives, if it was malified or palpably irrational, that means we have to scrutinize that whether the action taken was so unreasonable that it could be easily felt like, that it could be easily perceived as such, it was so unreasonable. So on the grounds of malified and palpably irrational, we can test the validity of the executive orders according to Justice P.V. Sawant. This is one standard. Second standard is by Justice Reddy. He said, no, we have to see to the advisability and the necessity of the action. That implies a broader evaluation of the situation, taking into account not just the legality of the action but also the intellectuality, the wisdom involved, the essentiality, right? So whether the action was justified and required under the circumstances, right? So hope you understood these points on which standards we are going to check the validity of the executive orders, right? So the judges took the Bommai ruling into account in order to constitutionally upheld the president's action in 2019. Right. Then we come to the second topic, that is Karan Singh's proclamation of 1949, who has been cited by the Supreme Court to uphold the abrogation of Article 370. So we just discussed that how Jammu Kashmir's element of sovereignty was discussed. It was debated if it is having an element of sovereignty or it is an integral part of India. So in upholding the abrogation of Article 370, the Supreme Court ruled that Jammu Kashmir is not having any element of sovereignty or internal sovereignty. It did not retain any such element after it joined the Union of India. By saying this, the judge D.Y. Chandrachud, the Chief Justice of India, he recalled that in November 1949, Yuvraj Karan Singh, who is the heir to the throne of Jammu Kashmir then, actually he was the son of Hari Singh, who signed the instrument of accession with Jawaharlal Nehru. He had issued a proclamation that reflected that now it's the full and final surrender of J&K sovereignty to India. That means the 1949 proclamation accepted the supremacy of the Indian constitution and thus surrendered all the sovereignty to it, where the sovereign was we the people of India afterwards. From thereafter, the sovereign was only the people of India, not any state. Then after the proclamation, the Government of India Act 1935, which until then governed the constitutional relationship between J&K and the India, Dominion of India, stood repealed. Right? So this was all about this discussion. You need to make note. Then we come to the third article of the day, that is about the Truth and the Reconciliation Commission. So here Justice Sanjay Kaul, who was one of the 5 judges in the Constitution bench, he recommended the setting up of a Truth and the Reconciliation Commission. So what is this commission about? It will look into any alleged violations of human rights by both state and the non-state actors in J&K since 1980s. Right? And he also said that it will be based on dialogue and it will be not like any criminal court. So it's like an official mechanism, not just to acknowledge but to also reveal any wrongdoings by a government or sometimes the non-state actors or combatants, so that the conflicts of the past can be addressed very smoothly and they can be resolved under the rule of law. Right? So this is all about the aim of the Truth and the Reconciliation Commission. So are we having already such commissions elsewhere? Yes, many countries are having, like South Africa, Australia, Canada, Uganda, Kenya. Then India's neighborhood countries like Sri Lanka and Nepal are also having. For example, in case of South Africa, the TRC, that is the Truth and the Reconciliation Commission, aimed of uncovering the truth of the human rights violations that happened in the apartheid regime, and thus it aimed to heal the country and bring about some reconciliation. Right? So this was all about the TRC. Let's now come to the fourth article of the day, that is, can Bihar increase its reservation pool? It is about the Bihar reservation laws. So why this is in news? Because on November 17, the governor of Bihar, he has approved 2 laws which has increased the quantum of reservations in jobs and education in the state to 75%. So 75% is much above the permissible limit of reservation in India. So what is the permissible limit of reservation in India? It is 50%. You all know about the 50% rule when we talk of reservation. So these 2 laws has again sparked a debate around the permissible limit of reservation in India. So there are 2 important points which we often consider when reservation talks are happening, right? It is about the 50% limit which has been prescribed by the Honorable Supreme Court of India in the Mandal Commission case. Right? In the Indira Sahani case of 1992, it has been prescribed that the reservation be limited to 50% only of the total seats or post. Then it has also emphasized upon having adequate representation on priority of the oppressed classes. We shouldn't go for proportionate representation. Instead of that, we should ensure adequate representation. So we would come to these two terminologies in the coming slides. So what is 50% rule firstly? That is the reservations whether in the jobs or education, it should not exceed 50% of the total seats or post. Again, in M.R. Balaji case of 1963, it has been said that reservations were completely an exception or a special provision that has to be extended under our constitutional scheme. It is not to be used regularly. It is not a normal provision to be extended every time. It is just an exception in order to ensure the representation, the adequate representation of the oppressed classes. So the 9-judge bench in the Mandal Commission case in 1990, they have reaffirmed the 50% limit. They have said that it is a binding rule. But yes, everything has got an exception. This thing has also got an exception where a state can exceed this limit. So in which cases the state can exceed this limit? Where it has to give reservations to any community who is hailing from far-flung areas of the country, number one. And the community has been kept out of the mainstream of the society for long. So these are the situations under which exception can be extended to a state to exceed the limit of reservation. So this is not a geographical test but a social one. Understanding, that is to ensure the adequate representation of the oppressed classes. So taking the advantage of the exception now, we have 103rd Constitutional Amendment, which provides for 10% additional reservation to the EWS. Now, therefore, the states are permitted to reserve a total of 60% of the seats, including EWS. Again, Chhattisgarh, Tamil Nadu, they are having much exceeding levels of reservation. Chhattisgarh is having 72%. Tamil Nadu is having 69% under a 1994 Act, and that is also protected under the ninth schedule, which is beyond the judicial review, but it was made under the judicial review afterwards. Then the northeastern states, they are having 80% reservation. Lakshadweep, like union territory, it is having 100% reservation for the scheduled tribes. So look at that, how the exceptions are made a norm. Now coming to the case of Bihar, what happened, that a caste based survey or census was conducted across the state. Then the results got announced. So based on the results of the caste-based survey, they have extended reservation to 60% now. They have reached the 50% limit. So now the question before Bihar would be that if they have adhered to the exception rule set by the Mandal Commission, right? It has to justify in front of the Supreme Court that it has adhered to the exception carved out in the Mandal Commission case. That is, if the communities to whom reservation has been granted, they actually hail from far-flung areas, or they have been kept out of the social mainstream, right? So this justification has to be given by the state government for the breach of the limit. And again, it has to explain that if it is giving adequate representation or proportional representation. So here the state of Bihar is saying that we are going for the proportional representation. We are actually looking into the quantum of reservation, which is actually not emphasized by the Supreme Court. The Supreme Court has emphasized upon the opposite viewpoint, that it wants to ensure adequate representation to the oppressed classes. So here the Supreme Court will be urged now to reconsider this limit, this ceiling limit of 50% entirely. So let's see what the court is deciding on. Let's now understand what is adequate representation, what is proportional representation. And the Supreme Court in the Mandal Commission case has continuously emphasized that we need to go for the adequate representation of the oppressed classes. So it is a qualitative aspect. It goes beyond mere numbers and focuses on ensuring that the voices, the perspectives, the interest, the opinion of the oppressed classes are genuinely heard. So it is a qualitative aspect again, emphasizing upon the need for the meaningful participation on the decision making process. Whereas the proportional representation is about numbers only. It is more quantitative, and it is concerned with achieving a particular distribution of representatives that mirrors the demographic composition of the population. So it may not guarantee that the concerns of the marginalized groups are actually heard. So this is the difference between the two. So state cannot actually fix the quantum of reservation simply in the proportion of the population, right? So it has to take care of the adequate representation aspect. So here the aim is to secure adequate representation, which is very different from the proportional representation that we discussed now, right? So this was all about today's discussion. So thank you so much.